Hi class, good day. Welcome to Legal Aspects in Hospitality and Tourism. And for this session, we will discuss the law on partnership and corporation. So, dalawang topic yung pagsasabay natin ngayon within just one video presentation. Okay, without further ado, let's define what is law on partnership. Okay, Articles 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So, kung titignan natin ang definition dito ng partnership, meron daw rito kontrata na nagkasundo ang two or more persons and they contributed money, property, and industry to a common fund at meron silang intensyon para magkaroon ng profits kaya nila ginawa ito. So, yun ang tinatawag natin partnership. So, most probably, they are dealing on the world of commerce. So, for further elaboration, partnership is an association of two or more persons to carry on as co-owners of a business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and other of similar nature because of partnership as defined by law refers only to associations the purpose of which is to obtain profits to be distributed among the partners. A partnership contract is based on trust and confidence. Hence, the fiduciary relation in a partnership stems from the principle of delictus personae, wherein no one can become a partner in a partnership without the consent of all the partners. So we have the essential requisites of a partnership here. So for number one, an agreement to contribute money, property, industry to a common fund. So this is complied with the following. A. Each one of the partners brings or is obliged to bring something to the partnership. Dapat merong contribution. That which is brought becomes common property. At itong contribution na to, hindi ito pang sarili, kundi para na yun sa buong partnership. Para na sa pagpapatakbo ng nasabing business. Now, for number two, intend to divide the profits among themselves. So, the followings are partnership is established to obtain profits. Profits must be common to all the parties. And profit or loss must be divided among the others. So, profit or loss, gumaguma ng business or nalugi yung business, still, equal pa rin yung distribution kung ano nga ba talaga yung nangyari sa business na ito. So what are the tests to determine the existence of a partnership? There are always two tests that we may apply in order to determine whether or not a partnership exists. So ano yun? 1 and 2. Whether or not there is an agreement to contribute money, property, or industry to a common fund. So dapat merong property, money, industry na ibibigay ko contribute ang isang tao para makapasok sa partnership. And for number two, whether or not there is an intent of the contracting parties to divide the profits among themselves. So dapat yung kasama sa partnership na yan, magde-divide sila ng profits. So let's have an example here. Assuming that there is a mutual contribution of money, property, or industry. Kasi sinasabi natin dun sa previous definition kanina, dapat may contribution money, property, and industry para masabing partnership to common fund. Okay? So here's the question. Is the receipt by a person of a share of the profits of a business conclusive evidence that he is a partner in the business? So yung pagbibigay niya ba ng yung pagbibigay niya ba ng contribution sa partnership ay masabi ng partner na siya kagad? Actually, hindi. Kaya nga kasama dapat yung dalawa na tinatawag nating two test kanina. What if nagbigay nga siya ng pera sa loob ng business na yan, pero ito pala ay for A. Debt payable by installments or otherwise. B. Wages of an employee or rent to a landlord. C. Annuity to a widow or to a legal representative to a deceased partner. And D. Interest on a loan or sale of the goodwill of a business or property by installments or otherwise. So, dapat masecure talaga natin ang dalawang test na binanggit kanina, ang pag-contribute and yung pag-divide ng profits. Kasi minsan, nag-contribute lang siya pero meron pala siyang utang or meron lang siyang loan na pinagkakautangan kaya nagbigay siya ng pera para sa business. So, that's how it works. So now let's move on to the classification of partnerships according to subject matter. Universal partnership, a partnership where all of the partners contributed all of their properties to the common fund and speaks of no particular purpose or subject matter, as long as the purpose in forming a partnership is to obtain profits and is not contrary to law, morals, public order, and public policy. So yun yung tinatawag natin universal partnership. While particular partnership has for its object determinate things, their use or fruits, or a specific undertaking, or the exercise of a profession or vocation. So classification of partnership according to liability. So we have general and limited partnership. For general partnership composed of a general partners where liabilities extend to their personal properties. While limited partnership or usually attaches the word Ltd or limited at the end of the company name, one formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the latter to third persons is limited to their capital contribution. And for according to duration, partnership for a fixed term is one in which the term of its existence has been agreed upon expressly, as when there is a definite period, or impliedly as when a particular enterprise or transaction is undertaken. The expiration of the term thus fixed the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. Now, let's move on to the different kinds of partners. So, kanina, partnership ang pinag-usapan natin, yung mismong business. Now, let's tackle the kinds of partners sa loob ng isang partnership. So, as to liability, we have general and limited partners. So, itong mga partners na to, for general, those who can be held liable for partnership obligations event to the extent of private property. So as you can see, yung general partners na to ay in line dun sa definition natin kanina ng general partnership. So now let's move on to limited partners, those who cannot be held liable for partnership obligations. So limitado lang sila as partners and they are not liable for partnership obligations. From the word itself, limited. So now let's move on to the different kinds. As to contribution, we have the capitalist and industrial. So what are the capitalist partners? Those who contribute money or property to the common fund. And for the second one, industrial partners, those who contribute only their skill or industry to the common fund. So, magbibigay ako ng tatlong example dito. A, B, and C, nagkaroon sila ng partnership. A, since mayaman siya, nagbigay siya ng pera. B, since may lupa siya dun sa mismong bayan at dun i-establish yung business, ang contribution niya naman ay yung location, yung property niya na lupa, and yung maliit na bahay. And C, sabihin na natin siya ay isang skilled businessman, siya ang masabi nating industrial partners. Since wala siyang kinontribute na pera or property, pero ang nakontribute niya ay skill para mapatakbo ang business. So still we're dealing with kinds of partnership pa rin. As to management, we have managing and silent partners. Managing partners are those who manage or administer partnership affairs, while silent partners, those who have no voice in the management of partnership affairs. As to third persons, ostensible partners, those who publicly known as such, yung kilalang kilala na siya ay part ng business na yan. Second one is the secret partners, those whose connection with the partnership is not known. They are also known as dormant partners. And last one, partners by estoppel, those who represent themselves or consent to another or others representing them to anyone as partners either in an existing partnership or in one that is fictitious or apparent. They are also known as de facto partners. So question, can a husband and wife enter into a contract of partnership? So the most fitting answer here would be depende. It depends. If a partnership is a universal partnership, a husband and wife can't enter into such contract. This is because under the New Civil Code Article 1782, persons prohibited from making donations to each other are prohibited from entering into universal partnership. So yung mga pwede magbigay ng donations, na mga personas, hindi pwedeng mag-involve sa partnership. However, if the partnership is particular or limited partnership, pwede silang pumasok sa isang partnership. So another question, how shall the profits and losses of a partnership be distributed? Okay, ang gandang tanong. Paano nga ba kung lumago ang business? Paano hatian? And paano naman kung nalugi ang business at meron na lang natitirang fund? Anong gagawin sa fund na yun kung nalugi? Or paano kung nagkautang pa yung business na yon, nalubog sa utang, ano ang gagawin ng mga business partners? So first, we must distinguish between a case where there is an agreement and one where there is no agreement. Kung meron daw agreement, kung magkano hatian, yun ang masusunod. The profits and losses shall be distributed in conformity with such agreement. If the agreement is only with respect to the profits, the share of the partners in the losses shall be in the same proportion as their share in the profits. So, meron kasi mga business partners dito na kung saan ang hatian nila, sinasabi na kagad nila under stipulation, 70-30 ang hatian. So, 50-50 ang hatian. 80-20 ang hatian. So, something like that. Kaya kung merong pinag-usapan, merong agreement, yan ang masusunod. So, let's dissect this scenario. Himay-himay natin kung ano ba talaga mangyari for profits and loss ng isang partnership. So, if there is no agreement, wala nakalagay na agreement, the profits and losses shall be distributed as follows. Kung lumago yung business, ano mangyari sa capitalist partners? Ulitin ko lang, ang capitalist partners, sila ang mga partners na nag-contribute ng money or property. The share of a capitalist partner shall be in proportion to what he may have contributed to the common fund. Kung magkano binigay niya, sabihin natin, nakabigay siya ng 80% yung capitalist partner na ito, then 80% din yung mapunta sa kanya for profits. For industrial partners naman, the share of an industrial partner shall be that which is just and equitable under the circumstances. Kung ano lang meron na magbibigay sa kanya doon as industrial partners, yun din yung equitable na nakadepende kung magkano binigay ng capitalist partners. For losses naman, what if nalugi yung business? For capitalist, ulitin ko, silang nag-contribute ng property or money. The share of a capitalist partner shall be in proportion to what he may have been contributed to the common fund. Same lang din. How about industrial partners? An industrial partner shall not be liable for the losses. So, sino nga ba mga industrial partners? Ito yung mga skilled sa business na yung contribution niya lang ay skill. So, kung malulugi daw, hindi siya liable for any loss. So, next question. Under our law, may the partners enter into an agreement whereby one or more of them shall not share in the profits and losses? Pwede ba yan? The answer would be no. They may not according to 1799 of the new civil code. Such an agreement would be void. Hindi pwede. Para ma-consider kang partner, dapat may contribution kang naibigay. Another question, can an industrial partner engage in the business other than that of his partnership? So, same question din. Can a capitalist partner engage in a business other than that of the partnership? Pwede ba na habang merong partnership, mag-engage pa sa business yung mga partners na to? So, sasagutin natin yan in a form of example. So, Jinggoy and Philip formed a partnership. So, merong dalawang partners dito, Jinggoy and Philip, to operate a car repair shop in Quezon City. So, anong business nila? Car repair shop in Quezon City. Jinggoy provided the capital while Philip contributed his labor and industry. So, masabi natin, Jinggoy is the capitalist and Philip is the skilled or industrial partner. On one side of their shop, Jinggoy opened and operated a coffee shop, while on the side, Philip put a car accessories store. May they engage in such separate business? So, maliban dun sa partnership nila, si Jinggoy, na capitalist, nagpagawa ng isang coffee shop katabi nun. On the other hand, si Philip din naman, meron din siyang business na katabi nun, car accessories store. So, anong mangyari? Pwede ba sila? May they engage in such separate business? The answer would be, Jinggoy, the capitalist partner, may engage in the restaurant business because it is not the same kind of business partnership is engaged on. On the other hand, Philip may not engage in any other business unless their partnership expressly permits him to do so, because as an industrial partner, he has to devote his full time to the business of the partnership. Okay, isa-isay natin. Si Jinggoy daw, pwede siyang mag-manage ng restaurant business na katabi dun sa partnership nila. Unang-una, yung business na ito, restaurant, malayo dun sa business ng car accessories. And pangalawa, si Philip naman, kung gusto niyang magtrabaho sa iba pang business, dapat humingi siya ng permiso kay Jinggoy kung papayagan siyang magtrabaho sa ibang business. Yung business din kasi na pinatayo ni Philip ay connected dun sa car accessories. What if yung partnership pala nila, pagkukuhanan niya ng mga supply and ibebenta niya dun sa car accessories. So, hindi yun maganda sa isang business kasi merong tayong makitang self-interest. And for such, industrial partner, ang contribution na lang na bibigay ni Philip is yung skill niya. At kapag nahati pa yung time niya, ibig sabihin nun, hindi siya devoted dun sa partnership nila. Now let's move on to the next question. What is meant by the principle of delictus personae in partnership relations? The principle of delictus personae in partnership relations refers to the rule which is inherent in every partnership that no one can become a member of the partnership association without the consent of all the partners. So sinasabi dito na bago ka maging part ng partnership na yan, dapat alam ng lahat ng partners na ikaw ay gustong sumali. So kung isa lang yung nakakaalam, therefore, hindi legit yung pagpasok mo sa partnership. Okay? So what are the three final stages of a partnership? The three final stages of partnership are dissolution, winding up, and termination. So ano nga ba to? Ito yung pagtatapos ng partnership. First, dissolution. The dissolution of a partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on the business. Winding up. The winding up refers to the process of liquidating partnership affairs, and for termination refers to that moment when partnership affairs are wound up. So now let's move on to the second topic, which is the corporation. So basics lang mapag-usapan natin dito. Section 2 of the Corporation Code of Philippines expressly provide that a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incidental to its existence. Okay? Kung iisa-isay natin to, ang corporation daw ay isang artificial being. Yes, he is a being, like ABS-CBN. He is a being. Kung sino ang presidente dyan, hindi siya talaga yung nagre-reflect kasi pwedeng mabago yung presidente kung sino may-ari ng corporation, but he is called an artificial being. Created by operation of law. So, paano siya na-create? Hindi siya pinanganak. Okay? Hindi katulad ng tao. Since artificial being siya, pinanganak siya, nagawa siya in a form of operation of law. And dahil nga, artificial being siya, he has also the right of succession, powers, attributes, and properties expressly authorized by law, inaturosan ng law, or incidental to its existence. So we have kinds of corporations here. First is the stock corporation, one which has a capital stock divided into shares and is authorized to distribute to the holders of such shares dividends or allotments of the surplus profits. Example is retained earnings. On the basis of the shares held, a stock corporation is organized for profit. The governing body of a stock corporation is usually the board of directors. So the second one is non-stock corporation, one where no part of its income is distributable as dividends to its members, trustees, or officers subject to the provisions of the Code on Dissolution. A non-stock corporation is one not organized for profit. The governing body is usually the board or trustees. The third, corporation de jure, a corporation organized in accordance with the requirements of law. And kung meron tayong de jure, meron din tayong tinatawag na de facto corporation. A corporation where there exists a flaw in its incorporation. So, merong problema yung corporation na to from the word de facto. So, explain ko na lang yan sa inyo sa discussion. So, number 5, public corporation, one formed or organized for the government of a portion of the state. It is created by its own charter for the exercise of public function. Examples, barangay, city, municipality, public corporation tawag natin dyan. Private corporation naman, one formed for some private purpose, aim, or end. It is created by incorporation under the General Corporation Law. This includes a government-owned and controlled corporation with an original charter and quasi-public corporation, a private corporation performing public functions. Okay, next, corporation sole, one organized for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church. In this corporation, there is only one incorporator. And next, a eleemosynary corporation, one organized for a charitable purpose. Domestic corporation, a corporation formed, organized, and existing under the laws of the Philippines. And the last one, foreign corporation, a corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in their own country or state. So ngayon pag-usapan naman natin ang government requirements for doing a business as a partnership or corporation. So maganda ito. Kung meron kayong plans right after you graduated in college or kahit ngayon pa lang, kung meron kayong pinapupusuang business, these are the simple requirements na hinihingi para makabuo ng partnership or corporation. So requirements for registration of business name under DTI. So kasi dapat pag maghanap kayo ng business name, ipa-register nyo na yan. So, huwag kayong kukuha ng registered name na kung saan ay nakuha na. Like, gagawa ka ng isang tindahan at papangalanan mo Jollibee or gagawa ka ng isang business, papangalanan mo ng Shopee. Okay? Hindi pwede yon. Since may nakakuha ng name na yan at nag-exist na. So, for partnership, articles of partnership, birth certificate of all the partners with their 2x2 pictures. For corporations naman, articles of incorporation, bylaws, certificate of incorporation, birth certificates of all the incorporators with their 2x2 pictures. So, mas marami ang requirements sa corporations compared to partnership. So, requirements for registration of business under the Bureau of Internal Revenue. So, acquire a tax identification number, business permit from the local government unit concerned, certificate of registration with the DTI, articles of partnership, articles of incorporation and bylaws, and 500 annual registration fee. So para legal na tumakbo ang business ninyo, dapat i-register nyo yan, both corporation and partnership. So that's it. We're already done with the law on partnership and corporations at basics lang yung tinakal natin. Thank you.